Hello, Professor. This is my exam 1 video. My first question was, why is the rule of law more important than the law itself? The rule of law is more fundamental than individual laws because it represents the principle that everyone, including government officials, is subject to and accountable under the law. While specific laws can be unjust or flawed, the rule of law ensures consistency and equal treatment. It prevents arbitrary exercise of power and provides a framework for peaceful resolution of, let's say, disputes or whatnot. Without rule of law, even good laws become meaningless if they're selectively enforced or ignored by those in power. I know you also talked about how the best form of government would be a benevolent dictator. We have a good king in Israel. Could have had the best king, but they rebelled and got bad ones. And you mentioned Thailand, Burma. These used to be benevolent dictators until their sons took over, and they were eventually bad dictators. And that's kind of when the rule of law fell apart. North Korea, communism took over as well. But these rules must be backed with enforcement and enforced fairly and equitably, or else it doesn't matter to have the laws in the first place, right? But we'll move on to the next question. Describe what corporate governance looks like. This is basically refers to the system of rules, practices and processes by which companies are directed and controlled. It involves balancing the interests of stakeholders, including the shareholders, the management, customers, and so on down the line. But good corporate governance is going to promote transparency, accountability, and ethical business practices while protecting the shareholder rights and whatnot. You also talked about how the top is going to be the investors, owners, and the shareholders, and how they manage their people is they elect a board of directors, and the board of directors is going to oversee the officers, and those officers have the right to hire and fire them and whatnot. And there's also the other stakeholders, the suppliers, customers, regulators, communities, and they also have to withhold corporate social responsibility. Let's see, question 3. Why avoid going to court? Well, court should be avoided when possible because litigation is very expensive, very time-consuming, unpredictable, very emotionally draining. Legal costs can escalate very quickly, and even winning parties may not recover all their expenses. Court proceedings are public, so if something goes wrong, you could damage your reputation. Sensitive information could go out. The outcome is always uncertain, whether you think you're going to win or not. I know you talked about that. How, you said, most lawyers lost the case they knew they were going to win, and won several they knew they were going to lose. But you also mentioned in the slides, John Roberts said litigation is costly and everyone benefits if disputes can be resolved efficiently with minimum expense and delay. The court system's always there, but God also commands us to settle those disputes between our brothers instead of going to the court system. It is a massive burden. You're going to be thinking about it when you're on a date, at night. It is emotionally draining, expensive. It basically takes a whole of your life. Move on to question 4. So this one is the difference between trial judges and appellate judges. So appellate judges are often called justices. Justices do not conduct the trial, but simply review it for error, and they heavily depend on the jury. Appellate judges will review any ruling on the trial judge relating to the law, but they don't care what the trial judge had to said about the rule of law. They care a lot about finding a fact from the jury. Justices give great deference to jury's findings of fact, but often review de novo any rule of law. Trial judges also often face tremendous caseloads and therefore tremendous pressure to move things through quickly. Many trials don't have a jury, so the judges also serve as a fact finder. So they have a lot to work through and a lot of work to do. So much. I mentioned there was one guy, I don't know if it was a son or something, but he just became a judge and on his first day, I think you mentioned he got 60 cases, which is insane. So that's a lot to handle. Question 5, how followers of judicial restraint approach litigation and review cases. So you mentioned a majority of followers of judicial restraint lean Republican, while majority of followers of judicial activism are going to be Democrat. However, all justices are going to have a little bit of both within them. But Basically, they believe that the political process, not the courts, should correct society's ills. Like Roe v. Wade, slavery, Dred Scott, like the court tried to correct society with, let's say, the 5 out of 9 people saying they know better than the elected representatives that like we vote for. They're more likely to decide an issue on a narrow basis if possible. Like the smallest decision possible is usually the best one to do. And they follow precedent whenever possible. That's their thesis. And they do not engage in judge-made laws, but interpret the letter of the law. And activism would be the opposite of what I just said. What is standing to sue, and what must the plaintiff allege to establish the required standing? They must have 3 things. Number 1, it must involve a controversy, some kind of wrong or injury, although there have been courts in the past just to tell people they were right. I mean, that's kind of crazy. 2, must have a personal stake or part of a group with a stake. In the past, like environmental groups were trying to sue companies and they were getting thrown out quickly because they hadn't been wronged. 3, it needs to be redressable in a court of law. Basically, what do you want the court to do to make it right? This is all before you get to the merits of the case. And after like those I mentioned, then you can have a case. I know you mentioned Juliana versus US, like citizens and NFPs, like they were suing about global warming, but never told them what they wanted done. They had no specific redressable item to identify. And you also the crazy one, in Colorado, someone sued on behalf of 5 elephants, and then a mountain in New Zealand, they can sue. So like there's some crazy stuff out there, but. And then what is a class action suit? So class action suit is going to be when you have like thousands of people with a common injury. Someone did some wrong to a lot of people. Like Apple would mandate updates on their software, but software was getting like bigger and bigger, so the older phones would stop working. So lawyers sued on behalf of 5 million users, and they got a $500 million lawsuit or settlement. And the lawyers actually got 30% of that, so they won pretty big. There was also Walmart versus Dukes class action lawsuit, like suing on behalf of 1.5 million female employees, claiming discrimination due to like underpay and underpromotion. But there was no common injury. However, all plaintiffs and vast majority probably didn't even know they were suing their employer. But it's basically a legal proceeding where one or more plaintiffs sue on behalf of a larger group of people who have similar claims against the same defendant. Last question. What is the purpose of discovery procedures? So basically the main thing here is to make sure both sides have all the facts. We want both sides to know everything so they can do interrogatories, which is presenting the other side with a list of questions. They can request for the production of documents based on answers from those previous questions. They can do depositions of potential witnesses where all words are recorded. They can request for an admission to narrow some of the issues. That's like narrowing the scope basically. I know you mentioned the dark waters example where Teflon in military, like that's like the thing in military like uniforms. But the guy named DuPont saw this material and wanted to coat pots and pans in this, but DuPont knew from the beginning it was causing numerous problems with like human bodies, like birth defects and whatnot. He's actually still suing going on, but the lawyer requested all the info. That's the discovery procedures. And he got sent a semi full of like all the stuff, and he actually went through it and like I guess found the right stuff to go forward with the case, which is kind of crazy. So good on him for sticking with his guns because he like lost his income and everything. But that is going to conclude my exam 1. I hope you enjoyed. Thank you very much. Have a good weekend.